Welcome to The Explainer. Today, we are diving into a landmark Supreme Court case that really gets to the heart of a huge question in our social media age. When do angry words, especially when they're dressed up as art or rap lyrics, cross that line from free speech into a criminal threat? Okay, so this whole story starts with a man named Anthony Elonis. Back in 2010, after his wife left him, he started posting what he called rap lyrics on Facebook. This incredibly graphic post was aimed squarely at her. He even made sure a relative saw it so he knew she would too. Now, you can imagine, his wife said she was, and I'm quoting here, extremely afraid for her life. So she got a protection order. Elonis' response? He posts this, asking if a piece of paper can stop a bullet. And just to really drive his point home, he included a link to the Wikipedia page for freedom of speech. But it didn't stop there, not by a long shot. He got fired from his job at an amusement park for another threatening post. And then he wrote this about local elementary schools. This is the one that got an FBI agent to visit him at his home. And that visit? Well, that led to yet another violent post, this time about the female agent. Through all of this, Elonis insisted it was just art. He said his writing was therapeutic, that he was just trying to be like rappers such as Eminem. He swore he never actually intended to threaten anyone. The government, though, saw it very differently. They saw a clear pattern of criminal behavior, and that's what landed him in court and eventually pushed this very question all the way to the Supreme Court.
So how in the world did a bunch of Facebook posts blow up into a federal case that could actually redefine the law? Let's walk through the timeline.
I mean, the escalation was incredibly fast. We're talking about just a few months. And in that time, Elonis' posts got him fired, served with a restraining order, and investigated by the FBI. And by 2011, a jury convicted him, and he was sentenced to almost 4 years in prison. He appealed, of course, arguing that the jury was told to use the wrong legal standard to judge him. And this, right here, is where things get really fascinating from a legal perspective. The appeal wasn't about whether the posts were violent. I mean, clearly they were. It was about what was going on in Elonis' head when he clicked post. We all talk about free speech, but the First Amendment isn't a free-for-all. There are categories of speech that aren't protected, and one of them is the true threat. The problem is, for a long time, the law has been kind of fuzzy on what exactly makes a threat true. Is it enough that the speaker just says something that sounds scary? Or do they have to actually mean it? This brings us to the absolute heart of the legal fight. On one side, you have Elonis arguing that the prosecution had to prove he subjectively intended to threaten someone. But on the other, you have the trial judge who told the jury to use an objective standard. Would a reasonable person reading these posts feel threatened? In fact, the government's lawyer told the jury, and I quote, "It doesn't matter what he thinks." So this huge conflict, what the speaker intended versus what a normal person would think, it goes all the way up to the Supreme Court. And that sets the stage for a major debate among the justices. Chief Justice John Roberts wrote the opinion for the 7-2 majority, and he sided with Elonis, focusing almost entirely on the defendant's state of mind. Roberts basically argued that a foundational principle of American law is that you have to have a guilty mind to be found guilty of a crime. He said that using a reasonable person standard, well, that's what we do in civil cases, like a fender bender. But for a criminal felony conviction, that's not enough. What Elonis himself was thinking, his mental state, that was the crucial element. It does matter. But Justice Samuel Alito, he strongly disagreed. In a pretty fiery dissent, he argued that the majority just fixed one problem by creating an even bigger, more dangerous one. You can really feel the frustration here. Alito was basically saying, okay, great, you told us the reasonable person standard is wrong, but you completely refused to tell us what the right standard is. He accused the court of dodging its duty of leaving everyone, judges, lawyers, you, me, in a state of total confusion. Okay, so to really get what the court did, or rather what it didn't do, you have to look at these different levels of criminal intent. The court said negligence, that lowest level, the reasonable person standard, is not enough for a conviction. They also said the higher levels, knowledge and purpose, are definitely enough. But then there's this crucial middle ground, recklessness. That's when you know there's a risk your words could be seen as a threat, but you post them anyway. And on that question, the court completely punted. They refused to decide.
So the court tosses out the conviction but doesn't give us a new rule. What on earth did that mean for Anthony Elonis? And really, for anyone who posts something angry online? So here's the final scorecard. Elonis's conviction was reversed. That's a win for him. The court made it clear that prosecutors have to prove some kind of guilty mindset. But by leaving that huge question about recklessness unanswered, they created this massive legal gray area for every future online threat case. And this decision really shines a spotlight on a fundamental tension in the law, doesn't it? On one hand, you have the majority, worried about protecting people from being sent to prison for a bad joke or some edgy art. But on the other hand, you have the dissent, worried that this ruling just gave every stalker and abuser a get-out-of-jail-free card. Oh, I didn't mean it. In the end, the Elonis case didn't give us a neat and tidy answer. Instead, it left all of us with a deeper and, frankly, a much more urgent question. In a world where our angriest, darkest thoughts can be blasted out to the world with a single click, where do we draw the line between expression and a threat? And more importantly, who gets to decide?